Hi, good morning everyone. Thanks for joining. We'll be starting the webinar shortly. If you do have a question for Lucy or Jessica, please do ask away. You've got a Q&A box at the bottom here, and we'll be going along to the question and answers shortly at the end. Okay, good morning everyone. Thank you for joining our Employment Law and HR webinar. For those of you that don't know me, my name is Hayley, and today we will be diving right into popular topics such as furlough, flexible furloughing and redundancies. And I wanted to start by saying well done to everybody in HR lately. Obviously you've been going through quite a bit of a busy time, to say the least. But really today I'm delighted to be joined by Lucy and Jessica from Ashtons Legal, who will be providing us with our expert panel and hopefully the answers to all of your questions as we go along. Lucy, can I head over to you for a short intro, please?
Sure, no problem. Well, good morning, everybody. For anybody that doesn't know me, I am Lucy Pakes and I'm the HR Business Manager for Ashtons HR Consulting. We are part of the wider Ashtons Legal firm, and I head up a team of HR consultants with Ashtons HR Consulting.
Fantastic.
And I'm Jessica Piper. I'm a solicitor in the employment team at Ashtons Legal. So we're part of a team across the firm, across all of our offices in Cambridge, Norwich and Ipswich and Bury St Edmunds, advising people on all manner of employment law issues.
Brilliant, thank you. Welcome, ladies.
Thank you.
Like I said previously, if you do have a question for Lucy or Jessica, please ask it through the Q&A section and we'll come to those shortly. But to start off with, I think there's been lots of updates recently from the government about furloughing, and often these tended to come on a Friday afternoon. I'm going to head over to Lucy now for a brief overview of the original furlough rules.
Okay, thanks, Hayley. We thought it was useful just to have a quick review of the original scheme. We've all come about trying to retain jobs and hopefully enable employers not to have to go too far down the redundancy route. If employers are now in a situation where you're having to start thinking about that, then Jess will be touching on that later on this morning in the webinar. So the scheme started with effect from the 19th of March. The availability for employers to furlough people closed as at 10th of June. So regrettably, if you haven't furloughed anybody yet at all, then it won't be possible for you to take advantage of that scheme now. The original scheme enabled employers to reclaim 80% of the pay of any employees that they had furloughed. And obviously with the changes coming into effect from tomorrow, 1st of July, those changes are going to mean that the amount you can reclaim will slowly ramp down. We'll look at that in a bit more detail shortly, but just to review in terms of your options, if you have furloughed anybody previously, you can furlough somebody again if they've already been furloughed previously. One of the questions we've had from a number of our clients is, does the person actually have to be furloughed now for me to furlough them again after the 1st of July? No, you don't. As long as they have been furloughed at some point in the period between 19th of March and now, then you can furlough them again, even if they're back to work at the moment. The main exception that the government's provided, which I think has been quite helpful actually, is if you have employees coming back from extended periods of leave, such as maternity leave. If you've got somebody coming back from maternity leave around now, then even if they haven't been furloughed already because they're on maternity leave, you can furlough them for the first time for them. So that's available for employees coming back from maternity leave, paternity leave, or adoption leave, or shared parental leave, every HR manager's favourite. There is some talk that if people are coming back from long-term sickness, it might be possible to furlough those people as well. But I think we're still waiting for the guidance on that, Jess, aren't we? We've heard rumours, but we haven't had anything definite from the government at the moment around that. So that's a bit of a watch this space as much as anything. Okay, we can go on to the next slide, please. Lovely. So these are the changes that are coming in with effect from tomorrow. And The only real change coming with effect from tomorrow is that now you can start being more flexible about how you furlough people. Up to now, you have been able to rotate people on furlough, so you can have them furloughed for 3 weeks, bring them back for a period, and then furlough them again for 3 weeks. With effect from tomorrow, it doesn't matter how long you bring them back for, or how long you furlough them for again if you need to. You could literally have them furloughed tomorrow, back on Thursday, and furloughed again on Friday if that suited your business. So that greater flexibility is now there and available for you. From the 1st of August, that's when some of the pay changes come in. So from the 1st of August, you can still reclaim 80% of the pay, but you will now have to start paying the employer's national insurance contributions and the employer's contributions to the pension scheme. From September, and indeed in October, you will still have to pay the national insurance and the employer's pension contributions, but from the 1st of September, you can now only reclaim 70% of the wages that you are paying, and the cap of 2,500 that's around at the moment obviously reduces proportionately. And then from the 1st of October, that's the last month of the furlough scheme, you can only reclaim 60% of any wages that you're paying. All through that period, though, employees are still entitled to receive 80% of their pay. So even if you're only reclaiming 60%, you will still have to pay the employees at least 80% of their normal pay. So that's the way the scheme is going forward, and the scheme ends on the 31st of October, as much as we know at the moment. We're not anticipating that will be extended any further. Okay, next slide, please. So, as I've already said, the minimum 3-week period for furlough no longer applies. So you can literally, if it suits your business, furlough somebody for 1 day and bring them back. And you have entire flexibility in terms of the pattern of hours that you want people to work. So there is no legal minimum you have to do. There's no minimum legal sort of limit to the number of hours you can ask people to work. There's no limit on the period of flexible furlough. You can, if you don't want to use flexible furlough and you have employees on furlough at the moment, you can keep them on furlough for right the way through, for full-time hours, right the way through to the 31st of October, if that's what you need to do for your business. So you don't even have to make use of the flexible furlough if it doesn't suit you. You do have to be making sure that any decisions you make are in line with employment law. So when you're thinking about which people to bring back, which people to leave on furlough, just be a bit careful around any potential discriminatory issues. So for example, with the best will in the world, you might feel it's appropriate to bring younger workers back and leave the older workers on furlough because potentially the older workers could be more at risk from the coronavirus, which is a perfectly reasonable, moral position for an employer to take. But it might carry the risk of a discrimination issue if the younger workers are saying, hang on, we're now at more risk and it's purely based on our age. So you might want to think about those sorts of issues a little bit carefully. As I've said, flexible furlough is possible from the 1st of July. You don't have to use it. If you are furloughing people, then the same rules apply as have applied all the way through the scheme. So employees cannot do any work for you. And the definition we've had from the government around work is that they cannot provide any services on behalf of your company, and they cannot do anything which would generate revenue for your business. However, training is not regarded as work, so you can ask employees to undertake training. It might be quite a good time to do it. If you've got any, for example, any mandatory online courses that you ask your employees to do, this might be a good time to make sure that they catch up, make sure they're fully up to speed with all of those. If they are doing training, they must be paid minimum national minimum wage for any hours that they spend doing that. So if for any reason the furlough payment you're making to them goes below national minimum wage, you do need to top it up back up to national minimum wage. An area where we've had a lot of queries from our clients is around holiday and what to do about the fact that employees are accruing a lot of holiday during furlough and obviously not necessarily able to take it. You can actually require your employees to take holiday during furlough. So if that's important to you to manage the accrual of holiday, as long as you give them twice as much notice as the holiday you want them to take, then you can say to employees, I will want you to be on holiday between X date and Y date. So if you want people to take a fortnight's holiday, for example, you'd need to give them 4 weeks notice. Okay, next slide, please. And I think this is passing over to Jess, so over to you.
Thank you, Lucy. So yeah, so looking at making claims under the flexible furlough scheme, some things are changing a little bit going forwards. In terms of what you need to make a claim, in relation to employee lists, national insurance numbers, bank account details for the company, etc. All those things are staying exactly the same. In terms of how you use the portal, but it's just the kind of procedure in how you claim that is going to vary slightly from tomorrow. So from tomorrow, you can only make claims for the relevant calendar month, and this is simply because the scheme changes now on a month-by-month basis, so it's to make it more straightforward for HMRC to know that the July claims are being dealt with in July, August are being dealt with in August. The last day to submit claims in respect of the period we've been in, 1st of March to 30th of June, is on or before 31st of July. Now, the guidance currently says that all claims in respect of July must be made by the end of July. There is some business groups that are looking at whether there will be any kind of buffer in that, because obviously you might not know until the last day of July what you need to claim for, but at the moment just to kind of keep that in mind and watch as the guidance unfolds on that one.
We've just had a question actually in Jess, sorry, from Millie asking about with the claims that you're making, are you still able to top up employees so they get their full-time salary? Yes, if you want to do that, yes, you can still do that. You don't have to restrict it just 80%, you can top it up.
Yeah, absolutely. That it's really important to remember from an employment law perspective that employment law sits slightly differently to this, which is a kind of state grant, really. So what you're paying your staff is entirely a decision between the company or the business and the staff member. You can agree that with them. If you want to pay them 100%, if you want to pay them 97.5%, that's entirely your call. And your agreement with them. So it's just what you will be able to reclaim under the scheme that's changing. And as Lucy mentioned, once we hit September, you have to be paying them at least 80% if you are utilising the grant in the scheme. I mean, if 80% is not possible, it is possible to vary the contracts entirely, but you just wouldn't be able to access the scheme at that stage. So in terms of the minimum claim period now is going to be 7 days, but you can wait and claim for the whole of July in one go, or you can claim in different periods. The only exception to that is if you get to sort of towards the end of July and you've been claiming 7 days at a time or whatever period at a time, and you're left with 2 or 3 days at the end, you can put a shorter claim in them, because obviously, as I say, you can't claim for any August days in with July. How you're going to calculate the wages is going to be the same as it has been in terms of people with variable hours. So either looking at this month last year or the average over the last tax year in the same way. And as we mentioned, you can still fully furlough people up to the 31st of October if that's what you'd like to do. Probably also just to add that the rules as within June continue. So if somebody is currently furloughed, they do need to be on a minimum 3-week period if they've been furloughed in June, even if that rolls them into July. So we just need to see out those minimum 3-week periods if they've started in June before we can start doing the flexible furlough with them. Now, the record keeping is going to change from tomorrow and becomes, well, it's being described as more onerous. I'm not sure that it is too more onerous, but you need to keep a record of the usual hours that the individual would work during the pay period, the hours that they have worked during the period, and the hours that they're furloughed for in that period. Now, we had a question last time that we ran a webinar on this topic that was, can I keep my records in days rather than hours? I don't see any issue with that, because you'd be able to quite quickly work out the hours if HMRC ever asked for them. So keep the records that are more straightforward for you. But I mean, essentially what you're doing is working out what's their normal pattern, what have they done, and what time have they spent on furlough. And that's how you work out then what you can claim for. Because the critical thing, and it does seem to be some confusion over this, is that you can only claim for the hours that the person is on furlough leave. There's no grant possible to reclaim towards any of the hours that they're actually working, and the hours that they're actually working will be paid as per the terms of their employment contract, whether that's 100% or whether you have varied that in consultation or by agreement with them. Now, those records about hours you're going to need to keep for 6 years on file, and you do need to have a flexible furlough agreement with them that documents the hours that they're doing, and keep that on record for at least 5 years. The tricky thing, and something for HR and to be mindful of, and we all need to up our admin skills on this one, is that any change to the furlough pattern you need to document. So you can probably put in a generic flexible furlough agreement, and then if you needed to change the pattern, you could perhaps do that just by a letter or an email. This will depend on your policies and contracts and things like that. Or you can do a whole new agreement every time. And I think it's going to very much depend on the needs of your business and how much that might be likely to change. So it might be that if somebody's working one pattern in July and then they're going to work another pattern in August, you think, well, actually, it's easier to do a full new agreement. Whereas if actually they're going to be on a standard pattern, but from the 25th to the 30th of July, I need them to cover someone's holiday and be back full time, well, I'll just document that by an additional letter to sit alongside the agreement. The main concern is that everything needs to be documented here so that you can evidence it in an audit, and that you keep those records for at least 5 years.
Jessica, can I ask you on that?
Yeah.
I was just going to ask regards to the flexibility around the scheme.
Struggling to hear you a bit, Hayley.
Sorry, you just dropped out.
You carry on, or am I okay now? Can you hear me okay?
Yep, you're okay now. Yep.
Okay, perfect. I was just going to say, with regards to the flexibility of the scheme, when you're talking about the agreement, is there an allowance there for complete flexibility? So if you wasn't sure of the hours that you could commit to, and it might vary week on week, is that something that you can do?
So what I would do is probably put an agreement in place at the outset that just made it clear that you are engaging in flexible furlough. Give an idea of those hours if you can, but if you really can't and you need to go back, I'm thinking particularly in sort of hospitality, you need to go back onto rota systems, for example. I think that agreement could document that your hours will be notified to you on a weekly basis or something like that. But you need to make sure, and none of us are particularly great at keeping records, I'm sure, and particularly in busy businesses whilst we're trying to work out how to operate in this new normal. But those records are really important. So it won't just be enough to have a flexible furlough agreement at the outset that says you might have to work some hours and we'll let you know, and then there be no other documentation about what those hours are. So I think that's fine to have, and then top it up with emails or letters or however you want to do it, but just make sure that you are documenting things as you go along.
Absolutely. That's a really good point there, Jessica. Thank you.
And just finally, and I don't know how many people this will affect, but from the 1st of July, any claim period cannot exceed the maximum number of employees you ever claimed for prior to the 1st of July. So if in a particular month in the last 3-4 months you've only ever claimed for 20 employees, going forwards in one go you can only claim for 20 employees. You can't start adding, even if they are eligible for furlough, you can't, you know, suddenly furlough 30 people in a particular period. Thank you. There's a couple
I'm just going to pick up, we've just had another question come through from Jessica, who is saying, in terms of flexible furlough, is there anything to stop employers bringing employees back for, say, 30 or 35 hours if they're normally on 40 hours without them being classed as back full time? I think, correct me if I'm wrong, Jess, I think my view on this is no, you absolutely have the flexibility to do that, but you do need to document it in a flexible working agreement saying, we're now bringing you back for 30 hours a week or 35. Because as Jess says, the furlough scheme has got two arms to it, if you like. There's the grant side of it where you're making a claim, and that's a relationship between you and HMRC. And there's the other arm of it, which is you as the employer working with the employee agreeing a variation to their contract. So as long as you have the paperwork to evidence that the employee is happy to vary their contract to say 30 or 35 hours a week, where previously they've been on 40, that's absolutely fine. You've covered the contractual side.
Yeah, absolutely agree with that. And I think that's a really valid point, though, to just emphasise that Lucy and I would obviously be more concerned about the employment law side than HMRC side. It is really important to remember that your staff, and we look at this in a minute, but your staff have the right at the moment, they've agreed to be on furlough to be at home and be paid 80% or the cap or whatever you've agreed with them, 100% if you have. And then they have the right to come back to work on their contract. Those are the two rights that they've got at the moment. So they don't have to agree to this middle ground of coming back a little bit and staying at home a little bit. To be honest, our experience is that the majority will agree, and probably 99% will agree. And people are being very understanding of the circumstances. But you do have to deal with that employment law angle properly and understand that you are asking them to consent to a variation of their contract by dropping some hours or working different days, working different shift patterns, however you need to do it to get them back. And you know, you need to consult with them if they're not happy about that. And part of that is understanding that people have other concerns that are relevant in these times, like, you know, if they've been at home on furlough, they haven't had to have concerns about childcare, and suddenly that might be a concern. Do they have concerns about safety? How are they going to get to work? All of these sort of things. So there is a HR piece around this that is very prevalent and does need to be handled very carefully, that sits alongside the kind of claiming of the grant. So in terms of the grant part, if they're sticking on full furlough, nothing changes. You claim as you have been claiming. If you're flexibly furloughing them, work out what they usually would have worked, and then work out their non-furloughed hours and their worked hours. You pay people in respect of the non-furloughed hours, and you can claim 80% as amended from July on the furloughed aspect. We've put in there that you should wait till the end of a period before making the claim in case the hours work changes. That's just a kind of practical point, really. There are systems in place now for adjustments by HMRC to rectify overpayments and underpayments, but you'll all be aware how busy they are, and it's probably going to take a little while to get things right if you've made a mistake. So just better not to make those errors if possible at the outset. They are turning around the payments quite quickly though, and they are saying that payments should be made within 6 working days of a claim being put in. I understand that it is often being quite a lot quicker than that anyway. So I do think they have got to grips with this pretty promptly by way as far as HMRC sometimes take. So that's a really good thing for businesses. For anyone returning from family leave, sick leave, any kind of leave where they've been on reduced pay, then you look at their pay based on what they were on before they went on that leave. So not the, if someone's returning from statutory maternity leave, you don't do it based on their statutory maternity pay. You work out what they were earning before that to work out the furlough rate. Thank you. Right, so as I mentioned, it's the crucial piece really is around getting the staff back, and you might be getting them back full-time or part-time, but however you look to do that, if it's full-time, it won't be so difficult because it's not a variation of the contract, so you just need to give them reasonable notice that they need to come back, and explain when they're expected at work, tell them what remuneration they will receive if you are looking to change that, and just be mindful that if you are looking to vary wages for a temporary or permanent period, then that is a variation of contract exercise, which can be very involved and potentially problematic. So you should really think carefully and take advice on that if you want to look into doing something like that. I'd recommend doing everything in writing, but following up with a phone call if you feel that that's appropriate. Also, really good idea to inform them of any changes that you're making in line with government and industry guidance. I think we're also busy at the moment trying to get our businesses safe and ready to return, and it's all quite easy to forget that some of your staff at least will be feeling very vulnerable and scared about coming back to the workplace. So even if we think, you know, perhaps you haven't had to make loads of changes, but it still might be a good idea to just drop a line to say, we know what our guidance is, we're working in line with the guidance, and these are the sort of things we're doing, whether those are, you know, we've just put hand sanitizer around the place, or this is how we're going to operate social distancing. So just be mindful of the staff's concerns, because dealing with this properly now will avoid any problems arising later. As I mentioned, the right is either to remain furloughed or to return full time. So if you want to bring them back part-time, flexibly furlough, change wages, change shift patterns, you need to agree that variation of contract. And ideally, look to gain consent in the first instance. It can be very straightforward. If they don't consent, then you might want to look at consulting with them to try and get consent. Ultimately, there are processes that you can go through to force the change. That might not be appropriate with regards to furlough. It kind of depends on the change that you're looking at making. So there's another question here. If an individual returns to work and their temperature is taken and is too high and we send them home, do they still get SSP from day one, or has this reverted back to before COVID-19? So I haven't checked the SSP regulations in the last day or so, but certainly as far as I'm aware, there's still, the amended SSP regulations are still in place, and they state that SSP is payable if there are symptoms of coronavirus, or you're living with somebody who has symptoms of coronavirus. So in that scenario, SSP would be payable from day one. Lucy.
Thank you. The other thing that we should have said as well about questions is any questions that you have that we don't get to answer during the session today, please do submit them to Hayley, and we will endeavour to pull together a list of all the questions that were asked and get answers out to everybody, so you'll all get to see the full picture of the questions and answers. I think the first two bullet points here on this slide, Jess has already covered for us. in terms of explaining to the employee what they can expect in terms of their contract when they come back. But the middle bullet point there, this is what we're finding with a lot of our clients who raise inquiries with us. They're in situations where some of their employees are saying, I'm just not comfortable to come back. They're either worried about their own health and safety, or they may be concerned because they're living with somebody who is shielding or is potentially vulnerable in another way. We've had a couple of employees concerned because they've got new babies, for example, and they're worried about partner and the baby. And the other thing is sometimes people, it's not just the COVID side of it, it's that fear of coming back. If they've been furloughed for a long period now, if they've been furloughed the whole period, they could have been off for, 3 months. Just the thought of adjusting back to a commute to work, being back in the workplace, the speed and the pace of work, having a lot of people around when there's maybe just been you and 1 or 2 other family members around, there's that whole psychological and emotional side to it as well. So I think we do need to be mindful of the concerns that employees have and do whatever's possible to try and address those. One of our clients is going to have return to work interviews with everybody when they come back, just saying, how was lockdown for you? How are you feeling about being back at work? Anything worrying you? And just giving employees an opportunity to express how they're feeling and see if the employer can address any of those concerns. There's also the health and safety side of it. Again, one of our other clients has arranged, they have a factory environment, and there was one individual who was very concerned about coming back into that and their personal safety. And the client has actually arranged for the individual to go back into the factory outside of working hours, just so that they can go around and see the hand sanitizers that are in place, the guidance they put in place in terms of moving around the factory, how they've rearranged the factory to show that there is now adequate social distancing available, just to try and reassure the employee and put their minds at rest around that. So it's worth thinking about that side of it, as well as the rules and regs and the legal side of it, and just think about the employee's personal morale and concern about coming back to work.
Yeah, definitely.
If employees consent, I think we've already covered this, but if employees do consent to come back to work and have a variation to change, we need to keep re-emphasising this, because as Jess said, we're not always, as HR practitioners or anybody else, terribly good at the paperwork. So it is important that you have a record of that, because HMRC have said that they will do checks. I don't know how they'll do it, given the scale of it, but they have said that they will check. So it's worth making sure you do have all your paperwork in order. And if we can be of any help at Ashtons, we do actually have template furlough agreements, flexible furlough agreements, and the letters you might want to use to just change any arrangements. If we can help with any of that, obviously do give us a shout. Okay, next slide, please. We've also got staff who are working from home. They might not have been furloughed. They might have been like Jess and myself, working all the way through, albeit from home. So if you're starting to ask those people to come back into the workplace, the first thing I think to think about is, remember the government guidance at the moment is still work from home if you can. So if people have been able to work effectively from home, then it is worth seeing whether you actually need people to come back in. Or if you do you need them back in full time? Can they maybe have 1 day in the office or the workplace and spend the rest of it still working from home to minimise the contact? At the end of the day, the virus is still here. It hasn't gone anywhere, and we don't have a vaccine. So the more we can minimise contact, the better. But if you are intending to bring people back into the workplace, again, write to them telling them this is what your plan is. Maybe a little bit of notice. There's no legal specified period of notice to give to people either coming back from furlough or working from home. But it's about being reasonable. I think Jess mentioned earlier, if people have got difficulties with childcare, because clearly nurseries may well be still shut, and parents might not be yet in a position to, grandparents in a position to do childcare for people, just give them a little bit of notice that the employee can actually try and make alternative arrangements to come back in again. There's a reference there to government and industry guidance. I don't know whether people have found this on the government website, gov.uk, but there is some very specific sector-related guidance. Yeah. I think there's some for offices, there's another one for retail premises, I think there's one for warehouses. So it's worth having a look and seeing if there is sector guidance that applies to you, and just checking that any arrangements you put in place to protect the health and safety of people when they come back, that those are in line with that sector-specific guidance. And again, if you've got any queries, talk to us, talk to Hayley, and I'm sure we can get a link sent out to you for the relevant sector guidance for your business. And then it's just thinking about different ways of working, really. We talked about PPE a lot. There's been a lot about that in the press, but also think about how people work. Can they come in shifts? So not everybody is arriving in the workplace at the same time and all queuing up to get in through the door. Can you space out desks or factories or whatever your environment is such that there is distancing? Can you just change the way you've worked up to now? Okay, now next slide, please. Okay, and this is back to Jess, I think. So this is if you are in a situation where you've taken advantage of the furlough scheme, but it hasn't been enough to cope with the business, you might now be having to think about starting to cut staff costs. Jess.
Yeah, so we're getting a lot of inquiries about this at the moment because people are very conscious that the furlough scheme is coming to an end. They perhaps don't feel able to top up wages, etc., even if the furlough scheme is continuing. Just might not be the money there. So people are looking at this, and it's also important you don't want to jump the gun and make decisions too quickly, but you need to be mindful of notice periods and things like that you are going to have to fork out for statutory redundancy payments. So just be thinking about those sort of issues when you're thinking about what to do next and the sort of time frame. In terms of looking at redundancies, the definition of a redundancy is a dismissal due to a workplace or business closure, or the diminished requirements of the business for employees to do work of a particular kind. So, for example, one of my clients has just had to make quite a few people redundant, unfortunately. He runs a pub, and his view is that even with being able to reopen, in terms of the social distancing that has to be put in place and the capacity of the public that can come back in, he had to cut his workforce quite substantially, and he just simply couldn't afford to start topping up beyond the end of July, even just the national insurance contributions. So it might be that even on a temporary basis, the social distancing or something is going to mean that the business has diminished requires for the amount of employees that you've got. So we talk about redundancy generally when people don't have work to do anymore. But it's really important to make sure we're aware of what kind of staff we've got. Have we got employees under employment contracts, or have we got workers under work contracts? And the workers, you might think of your 0 hours workers. These are your more casual people that come and go. There's no obligation to offer them work. And if you offer them work, they don't have any obligation to accept work. You do have to be a little bit careful that you're sure that they are workers, but if you are, then those people can just be let go if you don't have the work for them, or just they can remain on the books but not be offered any work. Although be aware that if they remain on the books, they continue to accrue rights to things like holiday pay, sick pay, and things like that. Your employees are the only ones that can officially, under legislation, be made redundant, although you can use the word redundancy to anyone if you so wish. And normal redundancy rules apply to anyone that's been on furlough as well. We don't have a mandatory statutory procedure for making staff redundant until you're making 20 or more staff redundant in one go. But if you're just making individuals redundant for fewer than 20 people within a 90-day period, then the process, in short, is to place those staff at risk of redundancy and explain why they're at risk of redundancy. Then it will depend exactly on the needs of your business, and you should really take some specialist advice at this stage if you're unsure. But it might be that this entire site is having to close, and therefore everyone's redundant. There is no suitable alternative employment, and we don't have much to consult on. We still have a couple of consultation meetings to discuss with the staff and see if there's any ways of avoiding the redundancies, or are there other sites that the staff are happy to move to. I've got this office in Cambridge, I have got another office in Peterborough. got jobs going there, oh, you know, you can't just think, well, they live in Cambridge, they wouldn't want to go to Peterborough. You have to think about offering this to them. But on the whole, things like that might be that the consultation is more limited. However, if you're going to need to go from 10 people working on this factory line to 5 people working on this factory line, then you need to look at doing a selection process and using objective criteria to measure people against each other, making sure you're not using anything that could amount to discriminatory treatment. So really avoiding taking into account absence days for maternity or sickness, if there's a disability, things like that. And really using objective criteria that you can measure and can show that you've scored effectively, and going through the process in that regard. The key thing is to act reasonably and fairly throughout the process. Try not to rush it. If you come to the point of confirming redundancies, then notice periods can be served whilst on furlough. There are very complicated rules around whether, if somebody is serving their notice period, you have to top up their furlough pay to 100%, or you can continue paying them 80%. Again, this is very case specific, and you should take advice on that. But if you want to be completely on the safe side, you should top up to 100%. They'd be entitled to their accrued but untaken holiday allowance to the end of the notice period. And again, depending on how you're going to utilise the scheme and the length of the notice period, you might be able to utilise some of the furlough time to cover the holiday as well. But that should be definitely topped up to 100%. And then if somebody has 2 or more years service, continuous service with the company, they're entitled to a statutory redundancy payment. And there's a handy statutory redundancy payment calculator on the gov.uk website, which is quite easy to use. Statutory redundancy payments cannot be reclaimed through the furlough scheme, so you have to pay those out of your own pockets, I'm afraid. There are special procedures that apply if you are making 20 or more individuals redundant within a 90-day period, and even more special procedures that apply if you hit 100 individuals. They are pretty involved and potentially very expensive if you get them wrong, and also there are certain parts of that process that carry potential criminal liability for the directors of the company if they are missed. So if you are thinking of making that many people redundant in one go, please take some advice from a lawyer or any kind of professional that you have regular contact with, like your accountant would also probably be able to assist. It is probably too involved to go through on this webinar, and will only apply to certain of you, but just be very mindful of the magic number of 20.
We've actually got a question, Jess, at the other end of the scale, which is, how would you apply a redundancy process if you're considering a redundancy for a marketing team which consists of only one person? You'd still have to follow the process that Jess has outlined in terms of consulting with the individual and exploring any options there might be to avoid the redundancy. But once you've gone through that consultation, if there is no alternative that either side can see to avoid it, then you would be able to proceed with a dismissal on the redundancy. So you still have to consult even if it's only one individual.
Yeah, and pools of one are quite common. But yeah, do try. The employer's obligation in law is to find ways of avoiding redundancies right up until the point that the person leaves the organisation. So this is another thing to be a little bit mindful of, because a lot of our clients are using the furlough scheme to pay out the notice period, which is perfectly reasonable. But if your notice period is running you through to the end of August, say, well, things might change between now and then, and actually there might be some more jobs back. So, you know, do you want to clear the decks of people quickly, in which case you might want to consider a payment in lieu of notice, which you wouldn't be able to reclaim from the furlough scheme, but would get people off the books once the decision has been made? Or do you want to utilise the furlough scheme and take the risk that, well, maybe it's a risk, maybe it's not a risk. Maybe you want to keep your staff, but you just don't have jobs for them. Or maybe, call me cynical, you might secretly want to get rid of some of your staff and perhaps if you leave it to roll over, you might end up in a position where there are jobs available and you would have to offer those to them. The case law around suitable alternative employment, if a job is completely suitable alternative employment in terms of your role, responsibilities, location, remuneration, seniority, etc., then if the individual refuses that, they wouldn't be entitled to the statutory redundancy payment. But often individuals will be able to demonstrate that roles are different enough that even if they refuse them, they are still entitled to that statutory redundancy payment. The thing to remember from the employer's perspective, though, is that it is an obligation to offer them any role that's available in the organisation. So even if it is the MD that you're making redundant and the only role available is for a cleaner, the case law says you have to offer that position even if you know that chances are they wouldn't accept it.
Okay, that's really interesting. Thank you, Amy, so much for that. We have got a couple of questions that have come in prior to the webinar going live today. So would you mind if I just run those past you?
Fine, yeah.
Perfect. So this question refers to flexible furloughing, and it's, do employers need to confirm a working pattern on a weekly or ad hoc basis, and does this need to be confirmed in writing? I think we did touch on it earlier, but would you mind just offering an answer for that?
Jess, do you want to
go? So it was, sorry, can you just repeat that question?
So do employers need to confirm a working pattern on a weekly or ad hoc basis, and does it need to be confirmed in writing with the employee?
Sure. Yeah, so I think, as we mentioned, I think ideally you'd put in place the key patterns if you know them. So do put what you can in place, and a lot of businesses will be able to put those patterns down in writing and stick to them. Perhaps there'll be a few changes along the way, but if you don't know, then I would put something in writing at the outset that says you've been brought back from furlough, you're not on full furlough anymore, you're going to be on part-time furlough, and we will notify you of the hours you're required to work by Saturday at 5 p.m. every week, and then every week just send them an email or a letter or something like that. Well, probably an email if you're going to do it so regularly, just to have a record of the hours that you're expecting them to work for the following week. I mean, I think that will be fine for the grant purposes. The key thing is to keep those records of the hours that someone's working, the hours that they're remaining furloughed. As Lucy says, we've no idea how they're going to audit these things. It might just be a complete threat, because there's a lot of people making a lot of claims to get through, but they may do spot checks and sort of random checks, and obviously HMRC do have a good few years to make these checks on things as well. So it's just about keeping the records and the patterns, but HMRC and the government have never specified a template or an exact form of words. So long as you can justify and identify, if someone comes and asks you in 4 years' time what that person did in July 2020, you can point to it and evidence it, then that will be fine.
Okay, perfect, thank you. And our next one was also relating to flexible furloughing, and it was about the minimum time or days that you can be on flexible furlough. I know originally it was the 3 weeks, and it's now changed. Is it to a week?
There is no minimum
No,
period.
No
There's
limit.
no minimum period at all. You can flexibly furlough somebody for 1 day if you want, or a fortnight, or whatever you want to do.
Great.
or even less than that. I mean, a matter of hours,
Yes.
actually, because you just got to do it on the hours that they're working. The 7 days is about the claim period. So yeah, so you can only claim for 7 days at a time.
Okay, perfect. And then the final one is it the case, again this is flexible furlough, that we can only make one claim for the whole of the July period to HMRC?
No, so you can make, so long as they're minimum periods of 7 days, other than, as I mentioned, if you're left with a couple of days at the end of July or at the beginning of the next month, at the beginning of July, and they tag on to a pay period. But in general, so long as it's a minimum 7 days pay period, you can claim. So you could claim for four times, I suppose, on average in a month, going forwards. But it's this bit about you have to claim for July's time in July, and we're still waiting to see exactly how that's going to work, and whether there'll be, there must be agreed a little bit of a rollover time that people can scoop up July's time. But I mean, certainly all of July needs to be sorted. Ideally, bank on it by the end of July.
Yeah. Okay, thank you. We have just had another question come through. And this is, we have a number of 0-hour staff who are currently on furlough. Do we still have to top up their pay to 80% in September and October? If they weren't on furlough, we wouldn't have any obligation to offer them any hours and therefore any pay.
Yeah, so 0 hours workers are the ones that most of our clients are looking at as a sort of starting point. The furlough scheme has been very generous to 0 hours workers, and probably rightly so from just a people perspective. But most of our clients are not keeping 0 hours staff on furlough beyond the end of July, once any contributions have to start being paid, because as you correctly identify, their contracts, there's no obligation on them to work or do any work or anything like that. So so long as you're sure that they are properly 0 hours workers, then I would just give them notice in writing that their furlough leave will end on the 31st of July or the 31st of August, depending on if you want to top up in August. But I think most people are ending at the end of July.
Okay.
I suppose the opposite also applies, Jess, doesn't it? If employers choose to keep on the 0 hours workers because they need them, if you are still following 0 hours workers, they would still need to be paid at 80%.
Yeah, that's right. Yeah.
And we have had another question come through. Thank you. If you have got any more questions, please keep them coming. We've got another one here, which is, if making someone redundant and contractually they have a 3-month notice period, do you need to pay them 100% pay for 3 months if they're on furlough?
The question that makes every employment lawyer and HR consultant cringe because it's complicated. Go on, Jess.
Thank you. It is very complicated. The starting point is that if I suppose just to explain, the law that we deal with is under the Employment Rights Act 1996. Furlough leave was invented by Rishi Sunak 4 months ago, so we don't have legislation that applies particularly to this. So we're trying to apply rules that have been created in other scenarios, like if somebody is off on long-term sick when they serve their notice, or on some sort of family leave when they serve notice. And that's why I mentioned earlier that the safest option is to pay 100%, because there is a chance that when this is ultimately tested in the tribunal, they might find a different way around interpreting the rules, but we are just trying to interpret it on the basis of sort of what we know and what we think is right. But if you compare it to somebody on long-term sick, for example, then the rules will say that if the person has 1 week's notice more that in their contract than they are entitled to under statutory rules, then you can pay them at the lesser sum of money. If they are only paid statutory notice pay, so a week's pay for every year that they've worked up to a maximum of 12, then you would have to top up to 100%. That is then slightly confused further because of the amount of time that we've now been on furlough. And if and because of the calculation period, you look back 12 weeks as to what the person was earning 12 weeks ago. So if so that might change again if they've been furloughed for the whole period. But that's a kind of general, hopefully that might be a bit more helpful, is that if your 3-month notice period that you're talking about is a contractual one, rather than, you know, they've only been there sort of 2-3 years, but they've got a 3-month notice period, then we believe that the legislative position would be you could pay them 80% for that period. If they've got a 3-month notice period because they've been there 20 years, then you would have to top up to 100%. I would try not to get too confused by this calculation date point, but it really is, I know it's, you know, probably sounds like I'm sitting on the fence, but it's very case by case and very specific. So if you want to be completely sure, then you should get somebody to look into that for you in terms of your specific circumstances. But that would be a guide. And if you don't want there to be any risk that you've got it wrong, you top up, and you could still claim the 80% from the scheme and top up the balance.
Because after all, a lot of UK employment law is actually based around case law as things go through the tribunals rather than legislation. Do you want to be the test case? That would be the answer. We did try as a team of employment law and HR consultants to come up with a flow chart to answer that question. And it went on to 2 sheets of A4, at which point we said, you know what, just safer to advise 100%.
Yeah, and I think I think the union-based employers, there probably will be test case on it, but we were already on about a 12-month delay to the tribunal before COVID, and now the tribunals have been shut for about 6 months. So it's one of those that if somebody wanted to fight you for it, it could take quite a long time to get an answer. So again, you know, you never like to sort of think like this because it's always unfair on the nicer employees, but if you've got a tricky employee, you might make a slightly different decision than if you've got one that's going quite amicably.
Okay, great. And then I guess a question that might be useful for people to know is, if someone is on furlough and then they go through the redundancy process and they are being made redundant, but potentially they might have been doing another job whilst they've been on furlough. How does that work? Can they actually work during that time?
What's their working different?
Yeah.
Employees? Yeah, so that's fine. If you're making them redundant from employer A, then their role at employer B doesn't change. I suppose that question in a bit more of a broader sense is something, as Lucy mentioned, when you're talking about getting people back to work and their concerns, there are quite a number of people actually who used the time being furloughed to go and get another job. They were entitled to do that if the employer was happy with them doing it. So I suppose you could get a few questions about well, I've now got to resign this job to come back here. So that will be an interesting one to deal with. But I mean, I would start with the starting point that if they want their job, then they can't go and work somewhere else anymore. But yeah, in terms of making them redundant, it doesn't have any impact on their other role, unless you want them to work for you during the notice period. And just like really briefly just touching on that, we've had a lot of questions from clients about what do I do if staff refuse to come back or really put their parts on because of, you know, even if they're legitimately just worried about coming back, or maybe they're just being difficult. I think go through the steps that Lucy mentioned in terms of trying to understand the problem, discuss with them, etc. I don't think you would rush straight into disciplinary action in these times in the same way that you might have done before. But ultimately, if you are sure that your workplace is COVID secure and they don't seem to have any reason for refusing, no childcare concerns, no nothing, they're just being difficult, then disciplinary action would be the kind of process to then follow. You just need to be quite careful that you are sure you've done everything right, because you don't want a whistleblowing claim to pop up in the background.
Absolutely. So aside from the points we've talked about today, other HR and employment law is going to be coming in the future. Is there anything pending that is going to change things at all in your field?
We've probably had the biggest one that the timing was perfect, which was the Good Work Plan, which, if people aren't familiar with it, was the legislation that says employees must be given a contract of employment from day one of employment, and also brought in a number of other changes about what had to be in the contract of employment to give some extra detail, and also introduced the concept of parental bereavement leave. So I think that was the biggie. It came in from April the 6th. So in terms of timing, combined with COVID, it was a bit of a nightmare for us trying to get appropriate information and update contracts and handbooks for our existing clients, while also telling them what to do about furlough. But I think that's the main one at the moment. Jess, what's coming up? Do we know what's coming up in the pipeline?
Well, there's a lot of reviews going on. As we all know, family-friendly leaves are always the kind of political batons that they use in employment law. There's been a consultation that did get parked but has been restarted around grandparental leave to support families with that would just be with unpaid leave, I think, is proposed. The other thing they're looking at, which is actually being debated in the Commons at the moment, because it is quite relevant, is in relation to redundancy protection for women returning from maternity leave, and whether we should go to the scheme they have in Germany, which is to protect jobs from redundancy for women who are on maternity leave for 6 months after they return from maternity leave. That's meant to be because maternity returners tend to be quite vulnerable in redundancy selection exercises because they've not been there for a period of time. So that's being debated at the moment. So those two things on the family side. But yeah, I mean, I think the Good Work Plan, there's some more changes that come in for that next year as well. And that will kind of tide us over a little while. And then I think it will just depend on Boris's magic money tree, because he's obviously talking about investment into infrastructure and jobs, and how that will then impact things like national minimum wage, national living wage rates, whether we'll see any more of a spike to those. Obviously we had quite a high spike already, and anything around protecting workers' rights in more general terms after we return from this sort of COVID era. So it will be quite interesting to see how COVID-19 will shape the landscape of workers' rights, particularly with a predominantly Conservative government, but a Conservative government that does seem quite keen on doing things to protect employment and protect jobs. So it's an interesting sort of time to be looking at the changes that might come in.
Definitely, absolutely. And from your client's perspective, has there been anything useful you think might find insightful today?
I think the key thing that's been cropping up with us, I don't know about on your side, Jess, but certainly with our clients, it is the return to work. It's the concern about, are people going to come back? How do we keep them safe? What about the ones that are refusing to come back? Those have been the main things. And I think it's ideas like the one I said about trying to reassure the employee by letting them actually see the workplace in a safe way. It's things like that. It's just listening to employees' concerns and trying to address them to encourage people to come back. That's been the main thing, I think, on our side of things.
Yeah, and I think also, and Lucy has done a lot of work on this in the past, but in terms of flexible working, obviously had a lot of probably a lot of our staff are working from home and have done for a period of time, and it's quite interesting that some of the correspondence, or there's been studies that have said that it's sort of in the region of 80% of those that have worked from home expect to continue working from home in some capacity on a permanent basis. And that will be very interesting in how people deal with the statutory flexible working requests that are made. Depending on your view as an employer, some employers are happy to accept flexible working requests. Some employers get very worried about it. But if you have had staff working from home, then question whether this has been an extended trial period for that has actually worked probably better than everyone expected, and whether you can, as an employer, realistically now say to somebody, no, your job requires you to be in the office Monday to Friday 9 to 5, will be an interesting probably a point I wouldn't want to test in court, because I think that would be quite difficult to argue. So that will add some challenges, I should think, and especially then even for our employers who are happy for people to continue working from home or working more agilely, and whatever that looks like to them. How do you manage people? How do you protect people? Look after health and safety when you're not seeing people? All of those challenges. And we're working a lot with our clients at the moment on those kind of topics. And I think as we're coming out of this sort of initial period of, it has been quite chaotic, but it's settling a little bit as we go forwards. It might be wise for employers to try and look at 6 months to 12 months from now, and what do you want your business to look like, and how are you going to support your staff, because also within that there'll be staff that desperately want to get back to the office, and we've got to remember those as well.
Of course, as you mentioned earlier, you are offering templates in terms of furlough agreements and contracts and variation of contract type services, so please do check that out. We will be putting Ashton's full detailed presentations onto our website, and we'll also email it out to all of you so you have got a copy. So ladies, thank you so much. We haven't had any further questions, so I think we're all good to say goodbye for now. But just to let you guys know, next week we will be doing another webinar, and that is all about motivation of employees working from home, mental health and well-being. So do register if that is of interest to you. But ladies, again, thank you so much for your time. And I'm sure everyone is grateful for your very valued advice.
Thank you for having us.
Thanks very much.
Thanks very much.
And I'll see you next week. Thank you. Bye.
Bye-bye.